the Rule 194 disclosure documents. We are asking the court to order $1,000 in, we'll call it attorney fees / sanctions, I guess, for the terminology. I have it listed as sanction request. And we'd like to have that paid by a date certain. We were asking the court to prohibit further discovery being propounded from Mr. Ampishaw. I'm sorry, Judge, my tongue's getting all tied up right now. And we are asking for, as it turns out, we're going to have to ask if the court also order us to get our mediation done by a date certain. We actually had mediation scheduled 5 times, with the 5th time indicating that discovery was needed. So we're trying to get this case done, Your Honor, and we're just being roadblocked every way we can.
I just lost somebody. Hold on, I just lost, for the record, we just lost Mr. Tracton. We're gonna go off the record and won't proceed until we get him back. While we're off the record, Ms. Blackwell, if the parties do agree to a waiver, if you can get that on the 387's website under the forms tab and circulate that, and that way we'll have that if that's what y'all are doing. But again, that's not something either side has to do. But if you're going to do it and we're going to set it all in one day, then I'd prefer to just have that resolved so that we have that done. There he is. Mr. Tracton, let me know when you've back up and running. We went off the record when we lost you.
It's giving me a little strange note. So I'm right in the middle of the screen that I was being live streamed. And I was trying to make it go away.
Oh, okay.
I made everything go away.
The court's back on the record in cause number 20 DCV 275222. Yeah, I normally do that as soon as I get on, and I forgot to do that this morning. This is on the Cesar. And ma'am, how do you pronounce the name?
Aponza.
Aponza. I've heard it pronounced different ways by, I think, everybody. So I probably will mess that up again. But on the Aponza case, Mr. Tracton, you were on your motion. You had stated that you felt like the case was being delayed and that you were wanting the court to get the case moving, a mediation done, and you may continue.
Yes, Your Honor, because we're pushing a year. And, we've been trying to make the case proceed. Just we're not able to get any, there's wheels spinning, but not getting anywhere.
Okay. Any further witnesses or anything further you'd like to call on your motion?
Probably, but no, Your Honor.
Okay, Ms. Brown, response?
Yes, sir. As I stated before we went on the record, this is a marriage of well over 30 years. There are no minor children. I have received a couple of boxes this past week from my client of documents that have to be gone through. I will tell you that I believe we did mediate, and that's correct. There was no discovery done by either side at that time. I think we mediated on temporary, so we did not settle. However, I will also let you know, it's not that we've not tried. I have done an inventory, so to say we didn't answer any discovery, I did do a basic inventory to the best of my ability based on what I was given from my client. In addition, I have received discovery responses from Mr. Tracton's office, and I know one of the things he's requesting of the court is that I not do any further discovery until we address my client's answers, which is I totally understand. But I will say his answers are.
I'm going to object to anything regarding answers unrelated to this matter, Your Honor.
Sustained.
And so there's been issues with discovery on both sides, and I understand he wants a date certain. But I'm asking that a fee be held until the time of trial, so we can
I didn't hear
address.
that, Your Honor.
She's asking that fees be deferred until the time of trial.
And that the court set a date certain, and we'll get our answers in.
All right, Mr. Tracton, anything further?
Yeah, Your Honor, I would ask that our fees are nominal compared to what we've had to incur, and we need this accomplished. We would ask that the fees be ordered paid at this time and not deferred, Your Honor. We're having too much trouble just getting movement. I believe that it's necessary for the client to understand a sense of urgency.
All right, thank you both. All right, Ms. Brown, I know you, well, let me look, my calendar. All right, the court's gonna, Ms. Brown, I'm gonna give you until October the 25th. That gives you 2 weekends, because it sounds like you may be having some staffing issues, and we've all been there. The court understands that, but that being said, this case, from my notes, when I was reviewing it, shows that it's 441 days old. So it's over a year old. It needs to get moving, and it looks like it's bogged down and going nowhere in a hurry. And so I am going to order that the documents and the answers be provided by October the 25th. I agree that since it sounds like the client just brought this stuff in last week, that there's not a sense of urgency on behalf of Ms. Brown's client. And it may be that there's issues with Mr. Tracton's client as well. That's just not in front of me today. I am ordering a $1,000 sanction. I'm going to say that needs to be paid by November the 5th at 5 p.m. to Mr. Tracton's office. I think that's reasonable, and it's meant to force compliance with the discovery order. So hopefully Mr. Mponza gets that in. The request to have his discovery abated or prohibited until he complies with the court order is denied. If he needs to conduct discovery, the court's going to allow him to do that, because I don't want to do anything that's going to slow this case down. So as far as mediation, since y'all mediated for temporary orders, the court is going to require you to go back in and mediate for final. But obviously both sides need to have whatever documents they need in order to make that a fruitful mediation. If we have the documents being due on October 25th, Mr. Tracton, I don't know if you need to supplement anything, because I didn't allow Ms. Brown to get into that since it wasn't before me. But if you need to supplement something, I would recommend doing that by around that same date, because I am going to order you all to mediate by December the 3rd. So the mediation deadline is December 3rd.
Can you pick a mediator too, Judge?
Well, Your Honor, we had a mediator 4 or 5 times. That was Sherry Travers, and that was the agreed mediator up through that point.
She's fine, Judge. She's fine. That'd be great.
All right, mediation will be through Sherry Travers then, and that will be on or before December the 3rd. I'm inclined to give you all a trial date too, just so we have an end in sight. And if the trial date doesn't work, the lawyers, y'all can come into court and request a different date. But I'm going to give you a trial date just so we have something set. And I'm going to do it at least 30 days out from the date of your mediation, so that y'all don't have to worry about supplementing and doing all that in the event the case settles. So we're looking at later in January of 2022. So looking at 24th, 25th, 26th, 27th, do y'all anticipate, it sounds like it's a one-day trial or a half-day trial kind of thing. Do y'all agree it can be done in less than 1 day?
No way. No, Judge. There's a
No?
lot of property, and it's a long marriage. We're going to need a day, and it's going to go to trial. So I'd rather just get a date and be able to go whatever date the court has.
So do y'all think it's going to be longer than 1 day?
I don't think longer, Judge, but I don't think it's a 2 hour. I mean, there's a lot of property.
Okay, so a full day. You agree with that, Mr. Tracton?
I'll go with that, Your Honor.
Okay. All right, so the court can do the 24th, the 25th, 26th, 27th is a jury trial, so we want to stay away from the 27th. So 24, 25, 26, if that works. Either of those dates work for the two of you.
Can we do the 25th, Your Honor?
I can do the 25th. That was what I was going to ask.
Great, that works. So January 25th of 22 at 9 a.m. For right now, that's going to be by Zoom. If you want, I'm thinking that eventually final trials will be back live, but I don't know that that's going to happen before January. So right now, we're going to keep that as a Zoom docket, and we'll see y'all back here on the 25th. Okay. Thank
Judge,
you,
are we
lawyers. Yes.
On the Zoom docket, are we able to object to the Zoom docket?
Well, you can object to the Zoom docket. I don't think it's going to do you any good right now, but especially if it was right now. But I'm there with you. I prefer being live as a judge. I would prefer being live as a lawyer. It's just such a better way to try a final case. I get doing Zoom for motions to substitute, motions to compel, motions to withdraw. But for final trials, I would much prefer it be live. But I'm not, necessarily the one making all those decisions in this county. So right now it's going to be by Zoom. I hope later on in the spring, we'll be back at least having final trials, but I don't know that for sure. Okay.
And Judge, as far as Ms. Brown, do you have any problem, Judge Bell hearing it?
I don't, but I don't have my client in my office, so I can't agree to that today. But
Sure.
as long as I talk about it with my client, I don't.
Yeah, y'all can circulate that too if you want to do that. And just once that's filed, the coordinator will know that it's coming to me, and we'll get you heard on the 25th, or try to get you heard on the 25th. All right, I'm going to give you an entry date for the order on the motion to compel real quick.
This should be an order in the file, Your Honor.
All right, let me take a look at that. All right, this gives her until May 6th.
That May 6th is when we filed for it.
It's May 6, 2022. Hold on, let me look. Sir, so that should be May 6, 2021. I guess that's when they were served.
Yes, Your Honor.
I got you. Okay. Okay, I just filled in October 25th for the date that the interrogatories are due. October 25th for the date the production's due. Are those disclosures out as well?
Correct, Your Honor.
Okay.
We need them.
Those will be due same date, October 25th. All right, I'm striking through that last paragraph in the order, Ms. Brown. So the
About the discovery,
Wait.
great.
pleadings are not stricken and there's no prohibition against doing discovery.
Yes, sir.
Can we add in the trial date, mediation date, or would you like a separate order for all that?
Can we just do a separate order?
I'd prefer just do a separate order. Y'all just submit that.
I'll take care of that.
Waiver with my client.
And so that order's been signed there. And then, look, if there's discovery issues, Ms. Brown, with the other side, y'all get that worked out, because I want y'all to have a fruitful mediation. So at least, I know y'all said it's not going to settle, but it's certainly not going to settle if anybody's missing documents. So
Yes, sir.
try to, both sides get their documents in so that y'all at least have a good effort to try to get it resolved. And if not, we'll see y'all back here on the 25th. Mr. Tracton, entry date will be a week from Friday, which would be the 20. Yeah, we need it. I guess we'll do it to the 22nd because we need it before the 25th. So entry will be October 22nd. Actually, I don't need, just sign the order.
You know,
On the order to mediate and the order for trial, if y'all can get that in by, I'm going to give you October 29th. Okay.
yes, Your Honor. Thank you.
All right, thank you, lawyers. Anything further we need to address from either side before we go off the record?
No, sir.
No, Your Honor.
Thank you, Ms. Brown. Thank you, Mr. Tracton. We're going off the record.
Thank you all.
Excuse me, Judge, I just sent that email with the documentation request.
Okay, I'll look at it in a second.
Thank you.
Okay, Mr. Zachariah, Ms. Blackwell, y'all had a chance to talk.
We did,
Yes,
Your
Judge.
Honor, and we've confirmed with Ms. Cuddy for the afternoon of October 22nd.
October 22nd afternoon, y'all are mediating.
Correct.
So what date would y'all like, Mr. Zachariah, Ms. Blackwell? I'm assuming you both want as quickly as you can get in. Is that right?
Correct. I'm available Monday through Wednesday of the following week.
I'm sorry, is it Zachariah or Zachariah? I don't want to mispronounce your name.
It's Zachariah, Your Honor.
Zachariah. Okay, I had it right the
Yes,
first
Judge.
one. All right, sorry.
Judge, I'm not available on the 25th or the 26th or 27th, actually, for that matter. I've got hearing on all those 3 days. But 28th or 29th, if possible, Judge, for October.
I have an arbitration on the 29th.
Looks like the 28th is y'all's best date.
Yes, Judge.
Wow, we have, you never know on these things. We have a lot set that day, but I can tell you, my view is y'all need a hearing. So hopefully we can get y'all heard on the 28th. So I'm going to make a docket entry that reminds me it needs to be heard, but I'm going to set y'all then for the 28th at 9 a.m.
Thank you, Your Honor.
So
And,
just to be clear, I'm sorry,
Yes, sir.
Judge.
Yes, sir.
So we just go ahead and circulate, file amended notices of hearing for the 28th.
You can. I'm making a docket entry that both of
Okay.
y'all are, that it's set, that the temporary orders. It looks like we have and the Band-Aid temporary orders I'm signing now.
Yes, Judge.
But the motion for temporary orders for both sides is going to be set for October 28th. And then it's my understanding that if it's me hearing it, the protective order is going to be heard at the same time. So that's something, if y'all get a waiver on file, then we're going to hear both issues at the same date. If not, then you'll appear, you need to appear with Judge Heppert's docket call anyways, but my guess is she'll probably just say she's here in the protective order, and then send y'all, reset y'all to hear the temporary orders with me, would be my guess, but I don't know. That would be her call.
Yes, Judge, but just to be clear, Ms. Blackwell, you have no objection to Judge Bell hearing these things?
I do not.
Thank you,
Okay,
Judge.
so yeah, y'all can circulate, either side can circulate that waiver, and then I'll hear y'all. And just if I don't, because it looks like we've got several temporary orders hearings set that day. You can also feel free to remind me that y'all been in before and that I said I really wanted to hear it. I think the fact that y'all have a protective order will allow me to reset other cases and take y'all first. So that's going to be the plan. If y'all don't get it settled, hopefully the court's going to have time to hear y'all, and we're going to, maybe that I put a time clock on you on the temporary orders. I'm a little less inclined to do that when it's a final trial. So since we are hearing the protective order as well, but I know both lawyers, y'all both been in front of me. Y'all both do a good job presenting your cases. I don't think we'll need to do a time limit. So, all right, y'all have a great day. And the Band-Aid temporary orders has been signed.
Thank you, Your
Thank you,
Honor.
Judge.
Thank you both. You are.
Thank you,
Thanks.
Judge.
All right, Mr. Correa, let me look for your email real quick. It'll just take me a second to read through this, probably 2 or 3 minutes, and then I'll get y'all out of here. But give me 1 second to find your email. There it is. So I'm going to print, I guess I need to email this to you so you can print it. And then I've got an email with pages 2 through 8, and then I'll sign the hard copy. Miss Torres, have you had a chance to review this email, the pages?
Yes, I have.
And you're good with everything in there?
Yes.
Okay. All right, I just sent them to you. Okay, so basically each party's keeping any retirement that they have, any property in their possession, any bank accounts in their name, and otherwise there's nothing else out there. Is that right?
Yes.
Okay. Looks good to me. All right, well, it's taking a second because she's got to print this up. We got to, and actually, you know what, I'm going to need, because they just, they emailed 2 through 8. So if you'll print out 1 through 9 also. All right, thanks. It's just going to take the clerk a second to print this stuff out. As soon as she gets me that stuff, we're going to get going, but I'm going to go ahead and swear y'all in while we're waiting. So if you would please each raise your right hand to be sworn. Do each of you solemnly swear or affirm the testimony that you're going to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you both. You can put your hands down. So Ms. Torres, you actually filed this action, so you're the petitioner. So you're the one that normally gives me testimony to grant the divorce. Do you know what to say, or would you like for me to ask you questions?
Ask me questions, please.
Okay. All right, Ms. Torres, you're presently married to, is it Dayan Correa?
Yes. That's correct.
Is that correct, ma'am?
Yes.
And prior to filing this petition for divorce, did you live in Texas for the 6 months immediately before you filed this petition?
Yes.
And did you live in Fort Bend County for the 90 days immediately before you filed this petition for divorce?
Yes.
Were there any children born or adopted during the marriage?
No.
And did you have any children with any other person other than your, did you have any children with any other man during this marriage?
No.
Are you currently pregnant?
No.
Have you reached an agreement with your, well, has the marriage become so bad the two of you can't live together as husband and wife?
Yes.
Is there a reasonable expectation if I don't grant a divorce this morning that the two of you could go back living together as husband and wife?
No.
Have you reached an agreement with your husband dividing up the assets and the debts the two of you have accumulated over the course of your marriage relationship?
No.
You have an agreement on who gets what property and who pays what bills?
Oh, no, nope. Just, we agreed that just everything's good.
Yeah, so I mean, you've got an agreement with him that says you're gonna keep what's yours, he's gonna keep what's his, correct?
Yes,
And ma'am, you think that's a fair division of your estate?
Yes,
And you want me to approve that agreement with your husband and grant you a divorce today?
yes, please.
All right, Mr. Correa, if I were to ask you all the exact same questions that I just asked, Ms. Torres, would your answers be the same or similar?
the same.
And you're telling me also that there's no hope of the two of you going back and living together as husband and wife, is that correct?
Yes,
And you also feel like the agreement that y'all have as far as the property that you do have, you feel that's fair to both you and your wife?
yes,
And you're asking me to grant a divorce and approve those agreements this morning?
yes.
Okay. All right, Mr. Correa and Ms. Torres, sorry for the wait, but the court has reviewed your paperwork now. Everything's in order. I'm approving the agreements that the two of you have reached, and I'm granting your divorce, and I'm signing your divorce decree. You can get a copy of this order from the district clerk's office, the same place that you filed the paperwork, and that'll be available in like 10 minutes or so. So anytime you want to get a copy of the order, you can just contact them, and they'll make arrangements for you to get a copy of the order signed by me. Okay? Best of luck to both of you. Y'all have a great day.
Thank you, Judge.
Your
Thank you.
turn.